Mr. Carrim was supposed to testify today, but he was hospitalized, so he can't be here today. But we do want to place on record certain issues. After Mr. Carrim wasn't available to testify at his last appearance and is now, well, after he wasn't available to testify at his last appearance, we asked that Mr. Carrim make himself available for examination by a specialist appointed by the Commission to confirm that he was indeed not medically fit to testify. And he hasn't yet responded or hasn't yet complied with that request. So we sit in a situation today where this is the second appearance for which Mr. Carrim has been medically unfit to appear. We're running out of time, and there are a whole succession of details and documents which he undertook in evidence to make available, which were then demanded of him in terms of notices and which have not yet been forthcoming. So we accept that he is not available to testify today, and that he has been admitted to hospital. So we can't have him here today. But what we would ask of the Commission is to postpone his appearance to the 15th of July. And our request, or our intention in relation to what will happen on 15 July is, obviously, if Mr. Carrim is here, he will be questioned. It will be the end of his testimony. If he is not here and is still, on his version, medically unfit, we will no longer seek his appearance on the 15th of July. But if he has subjected himself to independent examination by a specialist appointed by the Commission, and that independent specialist confirms his incapacity to testify, we won't ask for him to be called again. We won't have time to hear his evidence, but we will ask the Commission to make its findings in relation to all matters relevant to the evidence of Mr. Carrim on the basis of the evidence that he has already given, and on the basis of the evidence that he has thus far not answered, and his failure, if the failure still persists, to furnish audited financial statements, details of auditors, and the like. If Mr. Carrim does not agree to be examined by an independent specialist, then we will ask the Commission to recommend that he be prosecuted under Section 5 and 6 of the Commissions Act and Regulation 12(2) for hindering the proceedings of the Commission. And we will also ask for the Commission to make its findings on the basis of the evidence that we've heard thus far from Mr. Carrim, but no further evidence.
Regarding that proposed criminal process, I would imagine that the mental element would consist of intent, and are you basically saying that's something that would then have to be investigated down the line?
It would have to be investigated. I don't want to address argument on that, because I'm still hoping that one of two things will happen. Either Mr. Carrim will have recovered and will be here in 3 weeks' time, or his medical state will have been confirmed.
So that's an issue.
So it may never arise, but I want to give notice now that the Commission, or the evidence leaders at any rate, I can't speak for the Commission, the evidence leaders are taking this very seriously, because we We regrettably are of the view that thus far we have not received the necessary cooperation.
Yeah. I guess
from
at
Mr.
this
Carrim.
stage I'm going no further than just raising this so as to start thinking about it. No
Indeed,
further.
I'm not asking the
further.
Commission to
No
make
further.
any decisions at this stage, but I do need to place it on record so that Mr. Carrim and his legal team know where we will be going.
Okay, all right. Please continue.
So for present purposes, all that we would ask from the Commission is a postponement to 15 July. That's all I have to say at this stage.
Thank you, Mr. Shaskelson. Yes, Mr. Premier.
Or as I was saying, credibility, probability, veracity of the version. You'd have to engage with all of that. All I was simply saying about it depends on where that comes in. If it's the first step medical examination, that's where I may have a problem. But if it's the second step, which is what Chair is putting to me, unanswered allegations and what flows from unanswered allegations, to me that's the ordinary principles of evidence. That can't be objected to. Unless, of course, there's a question of Audi or whatever
All right, you may continue.
Thank you, Chair. But the second point I was going to make in respect of these the medical examination and less intrusive means is that, and I say this with due respect, because we're not in Uniform Rule 36 territory, there is no comparable direct access to a witness as far as I understand it. My understanding, and you'll know, for example, in the litigation involving President Zuma and the competency of his medical certificate that he used to excuse himself from another commission, if I'm not mistaken, which went originally in front of Judge Pillay, who might have acted with Judge in the Concourt, but is from the KZN division. There the contention was not when the commission, that commission, I don't want to call it the Zondo Commission, but you know which commission I'm referring to. When that commission had issues with the medical certificate and the medical fitness of the witness or otherwise, they had to impugn the medical certificate as the first step and potentially the person who authored the medical certificate, because that's the evidence upon which the witness relies to say, I should be excused from giving the evidence. So why I mention that is because what our learned friends say is that because they've come up against this medical certificate as they have, they must go directly to the witness and subject him to a medical exam from someone other than the doctor of his choosing. Whereas what they could do is they could engage the medical practitioner themselves. If they wanted to, they could have, we could have, I say we in the sense of if Chair gives directives to that effect. And again, I'm not committing myself to this version, I'm just theoretically testing the proposal put in front of you, is that we could have an in-camera hearing, because obviously we'd need to test the fullness of that confidential medical evidence, so it can't be for open public consumption. But then that's what we do, and the Commission might choose to cross-examine the particular medical professionals. They might wish to lead the evidence of their own medical examiner who, might give an expert view of the expert view that we've tendered. We might want to cross-examine their own expert. So that what I'm saying is that I'm not immune to the Commission's concerns about concluding the evidence of Mr. Carrim. But we've played open cards with the Commission to the extent that we can, by providing all the correspondence, by providing 4 medical reports, giving all the details of all the treating doctors, and before we must leapfrog to subjecting a person to a compelled medical examination, or potentially a voluntary one like Chair says, we must think about the balancing exercise of constitutional rights. And if there is less intrusive means that can nonetheless enable the Commission to do its job, then we would argue from the perspective of proportionality and reasonableness and balance, then that's an available mechanism. May I just make my last main submission? But before I do that, Chair, I don't know if you want to...
Just to say what Chair posits
Yes.
I think to say says sounds stronger to
No.
me. I think there's a nuance there.
Yes, no, then I withdraw every use of the word says, and I rather use the word posits. If the transcriber can edit the transcription, that's perfectly
No,
fine
they
by
don't
me.
need to. It's part of the engagement.
Yes, no,
yeah.
I accept that. And I'm grateful for the clarification, Chair, because also what I'm doing is I'm trying to be helpful to you, Chair, and the commissioners by engaging the debate and giving as cogent an answer as I can, hamstrung by the fact that I can't commit my client to a version in the absence of knowing the Commission's position and without instructions. So that's the rock in the hard place, the rock on my right and the hard place on my left, perhaps, that I'm stuck between in trying to engage you, Chair. So that's as far as I'm trying to take it. My third and last main submission, if I may, Chair, is that I've heard what my learned friend said about the recommendation for prosecution. Chair already identified mens rea as the requisite element and how that would need to be investigated, and then the prosecution would flow. All we'd point out is we've also addressed this in our letter of yesterday, which I take you got probably very late last night, if not early this morning, and we did say that if that's going to be the case, that the Commission, for whatever reason, chooses to make a motivation to the Commission that a recommendation be made that our client is prosecuted, that we get an opportunity to address the Commission before an adverse decision is potentially made against him, because that's Audi Rights 101. So Chair, that's to respond to what my learned friend said regarding everything else other than the 15th of July date. On the 15th of July date, we are in your hands and we will do as directed. Thank you, Chair. I'm indebted, and I know I've taken a long time, but thank you.
Thank you, Mr. Premier. Mr. Shaskalson?
Chair, I don't want to respond now because this is a debate, if it is ever going to arise, for another day. But I do want to place on record that we don't accept many of these submissions. And in particular, the one worrying thing that we see is what the medical reports disclose is that Mr. Carrim has not been hospitalized continuously since April. He tends to get hospitalized just as his appearances before this commission are scheduled. And that is worrying. And it's particularly worrying in the context of a situation where very basic, quite aside from his appearances, there are very basic requests for some documents to be furnished, like financial statements. It doesn't take much to issue an instruction for financial statements of a company to be made available to this commission if you're not in hospital. And what we see is a simple refusal to comply with these notices, coupled with a pattern of, as an appearance date appears, suddenly Mr. Carrim needs hospitalization. Now, it may be perfectly true. It may be that by coincidence, or possibly not by coincidence, his medical condition compounded by the stress of an imminent appearance requires his hospitalization. It is, I'm not saying it's not true, but it is worrying. And what is particularly worrying is that very, very basic requests for information have been outstanding since Mr. Carrim last testified, at a time when he was certainly fit enough to testify, fit enough to travel outside of the country, and we still wait for the documents that he promised us when he gave evidence. I don't want to say any more now. I'm hoping this never becomes an issue that we need to take further.
Now, for purpose, thank you, Mr. Shaskalson. For purposes of now, what sort of
all we want is a postponement
just a
until the 15th of
postponement
June. Nothing
period,
more.
nothing more.
We put stuff on record now so that
Thank you.
Mr. Carrim and his legal team know what our concerns are, but all we want is a postponement until 15th June.
Thank you. The hearing of Mr. Carrim's testimony is postponed to 15 July 2026. You are both excused.
Thank you, Chair.
Thank you.